We actually work with a bunch of different level of clients. So, I kind of group clients into three different general categories. So we have really, really sophisticated clients as it comes to like intellectual property. So in-house counsel at large companies that really know a lot about intellectual property law, as patent law, whatever. And, we kind of have really, really detailed conversations about the nuances of the law and the nuance of the position. And then in the middle, there's kind of maybe an in-house counsel that is more on the business side and isn't really, and is more really in tune with corporate issues. Maybe it's a smaller company and this one general counsel wears a lot of different hats. And so part of the counsel is kind of explaining them. They already know a lot about law and how generally law and litigation works, but they might not know the specifics about intellectual property or patent law, trademark law, or copyright law, any sort of intellectual property law. And so the counsel might change and the questions change, depending, maybe you talk more about like, what is a patent? What a patent can protect? How do you assert a patent? Same thing with trademarks, same thing with copyright. And the kind of the third category is probably like a complete, think of it in a startup scenario where, maybe it's a 5-person company and the person you're talking to is the founder, CEO, who's maybe a technical person, but has no, understanding of law and, has no experience with legal situations. And so there you're kind of doing not only just the technical specific type of law that you're working on, intellectual property, but you're also just explaining the legal system and how it works in the United States.